Welcome back to the Law News Network, everybody. This is Jesse Weber. Thanks for joining us. You are seeing the prior testimony in the Adam Matos case out of Pasco County, Florida. We're in a break today in that case. It's Veterans Day, so they're not going to be having court today. It'll resume on Monday. But we're recapping everything about this case, including anything you might have missed. We're replaying old clips. You heard that 911 phone call, and now we're going to be moving into other testimony from the day. Joining me now to talk a little bit more about it is criminal defense attorney Russell Novack. Russell, great to have you on. So much to talk about in this case. Now, I have to point on something that you said earlier before the break. You did say that it was an uphill battle for the state, or a possible uphill battle for the state, because it's a circumstantial evidence kind of case. In other words, we don't really have DNA linking yet Mr. Matos to a murder weapon or any of the bodies, but got to tell you, most people would say this is a slam dunk case, and pretty much because of everything that happened after August 28th, after the alleged murders happened. Would you not agree?
Not necessarily.
Our chatter just blew up.
I know. I'm watching it on my iPad here, and they can't. There's some eyeballs rolling out there in Chatterland. But basically, it's this. What I do as a defense attorney, I look for holes. I look for logical errors. I look for faults in the prosecution's case. And in a case like this, there are probably a few to find and exploit and argue to the jury about their meaning. So, number one, juries are very media savvy, they're very television savvy, they're very website savvy. One of the first things a juror is going to look for in a case like this, where obviously no one saw the killing, I mean, no one ever sees the killing in a murder case most of the time, is where's the DNA? Where's his DNA? Where are the victim's DNA? Is the blood mixed together, and so forth? There's none of that in this case, at least up until now. That's a really strong argument for the defense when it comes to summation time. The other sorts of things are a little bit more difficult or troubling to effectively argue away, convince a jury that they don't mean that much. For example, Mr. Matos going into this store and buying a shovel a few days after the murder. You know, the question, how is he going to explain away a juror's question, why on God's earth does this guy need a shovel? And why on God's earth did this guy using his dead wife's credit card to buy the shovel? And why was it, and to top it all off, the credit card transaction was declined.
And by the way, just to talk about that shovel, he went into Walmart, he tried to purchase a video game console, video game, and the shovel sometime between 11:30 and midnight on that day, and the sale was declined. Matos really wanted the shovel, though, so he asked to run the transaction again with just the shovel, and this time it went through. So, okay. So,
yeah, bad for the home team. I'll give you that one.
Yeah.
Really bad for the home team.
I'm going to give you all the facts, all the troubling evidence, but, I mean, again, really wanted that shovel. The problem here is we've seen cases where people get convicted when there is no body, when they can't even be found, okay? This, we have a quadruple homicide. The guy was living at the house, okay? He was ordering pizza at the house. He was selling their belongings. All the weapons were thrown into the canal behind the house. He left the crime area. He took a canoe out across the canal to another part of the area and took a cab around the area. He wouldn't let the people who wanted to buy the television, he wouldn't let them into the house. They said it was a mess. The house smelled of decomposition. It had a terrible odor. I think we'll keep going more into the facts, but this is, you can call it a circumstantial, but it is so strong against this man. So I don't know if I necessarily agree that it's an uphill battle for the prosecution. I think they're going to have a slam dunk.
Possibly.
Again, I don't know.
Possibly, but here's the thing. Number one, we don't know what sort of a defense case the defense attorneys are going to put on here. That's going to come after the prosecution rests. So we don't know what they have in their arsenal. The other part of this is oftentimes, and this might be one of them, there's always something to say. And what defense attorneys do and what lawyers do at a trial when it comes time to make their summation is argue inferentially. For example, they would say, well, if you have a certain set of facts, the prosecution argues that it means one thing. Well, if you look at it a little bit differently, perhaps I convince you that it means the opposite. conceitedly, in this case, it's a lot of these factual items that you mentioned about the weapons being found in the canal behind the house, and the part about the shovel and selling the dogs and the house smelling like death. That's hard. That's hard. Those sorts of things are sort of hard to argue to the jury that there's an explanation for them that's consistent with innocence or non-guilt. On the other hand, we don't know yet how the rest of the trial is going to pan out. Of course, the strongest thing for the defense here, no one saw Mr. Matos do it, right? It's all going to be proved circumstantially. He was the only one that had access to these people. The weapons belonged to him. And the things that he did post murder are consistent with guilt.
Right. Those are the things that he's being really prosecuted for.
Right. That's the prosecution's case. It's an after-the-fact case.
Okay, so you mentioned a good point. You said the word explanation. How do you explain his behavior? What we've seen, I've asked other guests before, we see it in the chat rooms, if you're the defense attorney, and we've had at least one guest say this is going to definitely happen, do you put your client on the stand to explain away?
You have
so what
to.
happens?
You have to.
So for what reason? How would it happen? How would it work?
Well, the prosecution would rest, and the judge would turn to the defense, and he would say, does the defense have any witnesses to call? And very dramatically, his attorney would rise and say, the defense calls Mr. Matos to the stand.
Okay, and there's gasps and shocks.
And there's gasps and shocked, and the papers get shuffled, and other defense attorneys start shaking their heads in amazement that why is he doing this?
Okay, so he gets on the stand, right?
Right.
The defense, do they question him about all of these things that were brought up by the prosecution? How do you explain ordering pizza? How do you explain leaving at the house? How do you explain buying the shovel? Do you go into each of those details?
He would have to explain each and every one of those strong pieces of prosecution evidence. He would have to explain why he's buying the shovel. He would have to explain, excuse me, why he's ordering pizza and why he's trying to sell the dogs on Craigslist for a very low price and so forth. He would have to come up with a cogent, reasonable explanation for all of those things.
But that seems like an impossibility, because here's the thing. Even, and I'm spitballing here, but even if he could explain, there were no bodies in the house. Remember, they were moved from, okay, there's no bodies in the house. There's blood everywhere around the house. We saw it. There was blood in the garage, on the mattress, on plastic bins. There was blood on chairs. There was blood on the wall. There was blood on the floor. There was blood stains everywhere. He's just going to live in a house with his son with blood and the smell of such a foul odor and not question where the family is. He said, remember, he told the McCanns, he told Ryan McCann and his family that was there, that the Browns had went to West Virginia, which is a lie. So again, you put him on the stand, it seems like a death sentence for him. No pun intended. But.
Well, it's a death sentence if you don't. You have to take your best shot here. And you have to, Mr. Matos has to testify convincingly and reasonably and an acceptable manner for him to succeed here. It's tough. It's really tough. I mean, as you said before, having he's going to have to explain living in a blood-spattered, smelly house, for X amount of days, and come up with a reasonable explanation for that.
Well, couldn't the other thing is you don't put him on the stand, which I thought, here's what I thought, okay? Let's back up. I thought the defense was going to put on an opening argument, and I thought that they were going to bring in this Michelle Stinson, this evidence that Michelle Stinson is a person who was stalking Nicholas Leonard, one of the victims in this case. And we're going to try to show suspicion placed on her that perhaps she had something to do with this crime. I was shocked that the defense didn't put on an opening argument, that they reserved their right until the prosecution closes their case, if they decide to even put on a case. Okay. Then I was thinking that they would keep attacking every single witness. You didn't test, any kind of forensic analysis, really delve deep into how it was not properly processed, any eyewitnesses, really grilling them. I'm not seeing it as much as I thought I would, so I'm not sure exactly what their strategy is.
Well, they have to have one. And a lot of times, in a capital case, you've got to go in there with something. In any sort of trial, you've got to go in there with a theory of the case. And at least at this point, based on what I've seen and the discussions that you and I have had, it doesn't seem like they have an articulable theory of the case yet. So when's the time to bring it out? When there's a defense case. And at that point, they're obviously holding back something. Is it Ms. Stinson? Is it something else? Are they going to call their own forensic people to combat it? I don't know. But you're not going to go to a criminal trial, let alone a death penalty eligible case, without a cogent theory of the case. And when I say theory of the case, it could be as simple as it was somebody else, or you have a reasonable doubt, or the science is crackpot, or 5,000 other different things. But you have to have something. There is a lurking intelligence back there. At least at this point, it's not very visible.
Yeah, no, I'm sure they have a plan, and I think they wanted to see what the prosecution was going to do with their case before they come on with theirs. Talking about explaining away certain things, we saw testimony yesterday from a Craigslist employee who introduced records of the various items that had been sold or that were being tried to be sold by Matos. They included TVs, dogs, cell phone, laptop, and audio gear. We also know that when there was testimony about Ryan McCann, we know that Adam Matos had asked him if he had surveillance cameras at his house. We know that people that tried to buy the dogs, Adam Matos had said that he was selling them cheap because he was having financial trouble with his girlfriend and needed to sell them. The pizza delivery guys showed up. They testified as well about delivering pizza, and they saw Tristan, his 4-year-old son at the time, at the residence. All these things that it's really difficult to explain away. I mean, that's really, again, I've never seen so much of a case where it's not so much the crime I'm looking at, but the behavior afterwards.
You have to get in there as defense attorney, and you have to dig, and you have to explain, and you have to offer reasonable alternative explanations for the testimony. So let's break it down a little bit. Let's look at the Craigslist stuff.
Yeah.
People sell every little piece of their personal stuff on Craigslist. So selling a dog on Craigslist, not unusual. Selling toys on Craigslist, not unusual. Selling audio equipment and television stuff on Craigslist, not unusual. Pick up a Craigslist 5 minutes from now and then buy any or all of those things. eBay also. So that in and of itself, not so terrible.
Even though it's not his stuff?
Doesn't matter. A lot of people go to Craigslist.
If I sell other people's stuff, you know how much trouble? I mean, you don't sell other people's stuff.
Well, when you sell stuff on Craigslist, and I'm not speaking from personal experience, but
That's a nice tie, Russell. I wonder how much I could get for it. You want to give it to me after?
Right. But people tend to, Craigslist, it's sort of the semi-anonymous, no questions asked marketplace. So if I want to sell a TV, or if I want to sell a pair of sneakers on Craigslist, I'm going to do it on a street, well, not a TV so much, but if I'm going to sell sneakers, I have a lot of clients who get in trouble for selling sneakers, Nikes on Craigslist. There's a big market in, rare Nikes and antique Nikes and so forth. But those transactions are done on street corners, so no questions asked. So selling junk or selling dogs on Craigslist was, hey, it's sort of like Craigslist is, hey, you meet somebody and go, hey, you want to buy a dog, you want to buy a TV. It's sort of assumed, I think, inherent in that transaction, that you're not going to ask too many questions about where the TV came from or what are you doing selling a dog in the first place.
Okay, he sells these items, wants to make some money, I guess.
Right.
You do it right in this time frame, right at the time of the murders?
Raises an eyebrow.
Raises an eyebrow.
It raises an eyebrow, but at the same time, it raises an eyebrow. Yeah, it's suspicious. Yeah, it's like, oh, why is he doing it then? But how does that tie with a murder? How does selling a TV show that you stabbed somebody and disposed of the body and, bought duct tape and so forth and so on and tie the body up and dispose of it in a horrible manner?
So let's just make it down. You're saying there's a difference between being the actual trigger man or the person who actually committed these crimes and a guy that maybe took advantage of their absence. Am I understanding?
No, I think that's
so what I'm saying is that you want to. I mean, this is great lawyering. Let me just start off there. Great lawyering. But the truth of the matter is, what you're saying is, okay, you can't pinpoint him to being the actual killer, but you can pinpoint him to being the guy that took advantage of the situation and did things afterwards and was acting in a questionable behavior. But none of this says that his fingers were on a murder weapon, that he actually killed these people, which is what he's on trial for.
That's the ultimate issue. You're right, Jesse. That's right.
Now,
that's right.
That's why we do have circumstantial evidence cases.
That's why I have circumstantial evidence cases. And when judges read their charges to the jury at the end of all the evidence, when the judge instructs the jury on the law, they're going to tell you that circumstantial evidence is okay, but it has problems. And then the judge is going to give the jury instruction about how to evaluate circumstantial evidence, certain tests they can use. New York does it a certain way. Florida maybe does it in a similar way. I just don't know what the Florida law is on this because I've never practiced down there. But the jury is the ultimate decider of facts. And the only issue for this jury to decide here is whether or not Adam Matos is the killer.
So you're saying that when we would hear the defense's closing, I'm assuming they would make some sort of, maybe an opening.
Oh, they better
do something. They better do something. They're going to say, what do we know? This is what the prosecution has shown. They've shown that he did this, he did this. Did they ever show that he shot anybody? Did they ever show that he stabbed anybody? Did they ever show? So that's how they're going to articulate it. That's one avenue to go towards.
And the DA is going to say, well, of course they don't, because in most murder cases, nobody's around to tell the tale. Right? Dead men tell no tales. Right. So then what the defense attorney is going to have to do here, he's going to have to argue inferentially. Basically, he's going to have to say, well, what does this mean? Why is this significant, or why is this piece of evidence not significant? And if you think this piece of prosecution evidence is significant, here's why it's not. His summation, this attorney's, or a summation in this case, is going to be, and I don't mean to make light of it, but this is going to be the summation of his life. If he's going to win this case, he's going to win in his summation. He's going to win it in the last half an hour. Well, I don't know, it's a homicide case. Probably in the last hour and a half of his case.
Okay.
Of the trial. That's where this case is going to be, won or lost. It's going to be in the defense attorney's summation.
Russell, I'm not done. I have a lot to talk to you about, but I do want to play some more clips for our viewers in the meantime. So again, this is now the testimony I want to play for you from Deputy Frederick Heidgarten. He's a patrol officer. Let's play this testimony. Russell and I will be back to discuss this case. I have to keep questioning you about this amazing defense tactics, and maybe the defense attorneys will be listening to you when they make their closing arguments. But I have to say, so far, it's not looking like a good case for their client, but again, we have to see what they will do. But in the meantime, Russell and I will talk about it in a minute, but I do want to play for you some prior testimony in the Adam Matos case. It will resume on Monday. It's off for today, and we'll be back here with more analysis.
I was a patrol deputy with the Pasco County Sheriff's Office.
And can you tell the jury what were your duties as a patrol deputy?
I responded to calls for service, various nature calls for service. I wore a full uniform and had a fully marked patrol vehicle.
Back on August 28th, 2014, in the morning hours, between 6 and 6:30 in the morning, were you on duty at that time?
Yes, sir, I was.
And did you have occasion at around 6:10, 6:15 in the morning to respond to 7719 Hatteras Drive?
Yes, sir.
And can you describe for the jury when you got there kind of what the residence looks like, basically?
The residence is on the corner of Hatteras and Old Dixie Highway, and it faces to the south. When I pulled to the residence, I parked in front of the residence, and it's a two-story building with garages on both sides and a front entryway that leads up to the residence front doors.
Okay, and did you go up those stairs and knock on the front door?
Yes, sir, I did.
And prior to making contact with people at a residence like this, do you have information that is gathered by the 911 dispatcher?
Yes, sir.
Do you have basic information about either what to expect or what the call may be about?
Yes, sir.
And is that information important to you to know how to appropriately respond to a potentially emergency situation?
Yes, sir, that information is crucial.
And in this particular call, you had familiarized yourself with some of that information?
Yes, sir.
Now, when you got up to the door, who answered the door?
A female who I identified as Megan Brown answered the front door.
And Megan Brown, female about 27 years old?
Yes, sir.
And how was her demeanor when she answered the door?
She was frightened. She was shooken up when she first came to the door.
Okay. And as part of your job, do you conduct investigations?
Yes, sir.
And to potential crimes or circumstances?
Yes, sir.
And did you conduct an investigation at 7719 Hatteras Drive?
Yes, sir, that morning I did.
Did you speak with Megan Brown?
Yes, sir.
And did she speak with you?
Yes.
She cooperated with you?
Yes, sir.
Did you notice any injuries to Megan Brown?
Yes. After arriving on scene, she did advise she had an injury to her left thumb.
Okay. And did you see that?
Yes, sir, I did.
Did you photograph it?
Yes, sir.
Now, while you were there, did you have occasion to be in the living room area just inside the front door?
Yes.
And did you notice that there was an entertainment center in that living room?
Yes, sir.
Was there a television set in that entertainment center?
Yes, sir.
Now, aside from Megan Brown, when you're there, it's 6:15-ish in the morning. Were there any other people that you observed in the residence during that contact?
That time in the morning, I observed her son, and then I also spoke with her mother, Margaret.
Okay, and her son is approximately 4-year-old boy?
Yes, at that time, yes, sir.
Okay. And did you have occasion to go into a little boy's room?
Yes, sir, I did.
And could you tell it was a little boy's room based on the toys?
Yes.
Things? And was that part of your investigation to document that?
Yes, sir, it was.
Did you take photographs in that room?
Yes, sir, I did.
While there, did you also have occasion to observe the room across the hall from that, which would be the southeast bedroom, Megan's bedroom?
Yes, when I walked in, there was a hallway, and there was 2 rooms on both sides. I looked into the room behind me as I walked into the boys' room, and I looked into that, be the southmost bedroom on that side of the house.
Was there any type of bed in that room when you looked in there?
Yes, when I did walk in, when I looked to the right, I remember looking down and seeing a bed on the floor.
Like a mattress?
A mattress, yes, sir.
Okay. Now, based on the allegations, did you determine whether or not Adam Matos was present at that residence?
Yes, during my investigation, Megan Brown advised that he was there the morning of.
Yeah, but at the time you were
Oh,
present?
at the time I was present? No, he was not there when I was there present
Okay.
at that time.
Were you interested in locating Adam Matos?
Yes, sir, I was.
And did you try and do that?
Yes, sir.
And actually, how long do you think you were at 7719 Hatters Drive? Or do you know exactly how long you were there?
I was there
the
for,
first time?
from when I arrived until when I cleared the call, it was approximately maybe a few minutes less than an hour and a half.
Okay. So approximately 7:45-ish, 7:30 is the time that you're leaving Hatters Drive. Now, after you leave Hatters Drive, did you make some attempts to locate Adam Matos?
Yes, I circulated the general vicinity of the area, up and down Old Dixie Highway, and I drove all the way down to a restaurant called Get Hooked, which is on the corner of Hudson and Old Dixie Highway, and didn't see any signs of the description that was given to me for the suspect.
Okay. Now, is there any particular reason you didn't use canines or anything to try and locate him?
After my arrival on scene, I was advised that he potentially left on a bicycle, and with a time delay, a K9 would not have been useful with how fast one could travel on a bicycle and the time delay we had.
Okay. Now, that same morning, did you have occasion to respond back to 7719 Hatters Drive?
Yes, sir, I did.
Approximately what time did you respond back to 7719 Hatters Drive on August 28, 2014?
I responded back to the residence approximately 9:10 a.m.
And what were the circumstances that led you to respond back to that residence?
There was another 911 call placed about the incident that had occurred the morning of, and the caller was under the impression that that incident was reoccurring. When I got to the residence, I made contact with Megan Brown again.
Okay. And when you made contact with Megan Brown, other than the situation that had already happened, was she okay?
Yes.
No new injuries?
No, nothing new.
And while you were there the second time, did you see any people aside from Megan Brown?
Yes, sir.
Who'd you see?
Greg Brown, who was standing in the living room behind Megan at the front door.
White male, approximately 52 years of age?
Yes, sir.
Approximately how long were you present that second time?
I believe about 12-15 minutes, somewhere in that time frame.
Okay. And was it your understanding that the caller who placed the second 911 call that you responded to at 9:10 was Nicholas Leonard?
Yes, sir.
Judge, may I approach the witness?
You may.
I've previously shown these photographs to defense counsel.
Okay.
Deputy Heydrich, I'm showing you what's been previously marked as State's Exhibit 2 for identification.
Sir.
Do you recognize that?
Yes, sir.
Is that what is that?
That is a picture of the front of the residence.
Residence at 7719 Hatters Drive?
Yes, sir.
Is that a photograph that you took at between 6:10 and approximately 7:45 in the morning of August 28, 2014?
Yes, sir. That's a photograph I took.
And is it a fair and accurate depiction of the way things looked?
Yes, sir.
Judge, at this time, state would like to move State's Exhibit 1 for identification into evidence. Or, I'm sorry, 2. Into
Any
evidence.
objection to 2, the photograph of the front of the resident?
No, Your Honor.
All right, State's 2 will come into evidence.
Turning your attention to State's Exhibit 3 for identification. Do you recognize that?
Yes, sir, I do.
And what is that?
That would be a picture of the child's room.
Okay, is it a photograph that you took the morning of August 28, 2014 between about 6:10 and 7:45
Yes, sir.
in the morning?
Yes, I took that picture.
And is it a fair and accurate representation of what you saw?
Yes, sir, it is.
Excuse me, sorry. Judge, at this time, State would like to move State's Exhibit 3 for identification and evidence.
Any objection of the photograph? I assume you've seen all of
I
it?
have, Judge, no objection to any of the photographs.
Okay, so State's 3 will be in as 3.
Showing you State's Exhibit 4 for identification. Do you recognize this?
Yes, sir, I do.
And what is this?
It's a close-up picture of the corner of the bedroom.
And is this a fair and accurate depiction of the way it appeared the morning of August 28, 2014?
Yes, sir, it is.
Showing you State's Exhibit 5 for identification.
Are you going to move forward?
I'm going to try to do a little faster.
That's okay.
That's okay, Judge.
Okay.
Showing you State's Exhibit 5 for identification. Do you recognize that?
Yes, sir.
What is that?
It's a picture of blood on top of a container box in the corner of the bedroom.
And this is still the little boy's bedroom.
The little boy's bedroom, yes, sir.
Is this a picture that you took the morning of August 28, 2014
Yes, sir, it is.
during your first response to 7719 Hatteras Drive?
That's correct.
Showing you State's Exhibit 6 for identification. Do you recognize that?
Yes, sir, I do.
And what is that?
It's a close-up of the previous picture of blood splatter on the container box in the corner of the little boy's bedroom.
Is this a fair and accurate depiction of what you observed and documented on August 28, 2014 in the morning during your first visit?
Yes, sir.
Judge, at this time, State would like to move State's Exhibits 4, 5, and 6 into evidence.
Any objection?
No, Your Honor.
All right, States 4, 5, and 6 will come in as evidence.
Turning your attention to State's Exhibit 7 for identification. Do you recognize this?
Yes, sir.
What is that?
That is a picture of Megan Brown.
And is that a photograph that you took the morning of August 28, 2014?
Yes, sir.
Is it a fair and accurate depiction of what you observed?
Yes, sir.
And where is she standing in that photograph?
She's standing at the front entryway of the residence, right in front of the front doors.
Showing you State's Exhibit 8 for identification. Do you recognize that?
Yes, sir.
What is that a photograph of?
That's a picture of the cut I observed to Megan Brown's thumb.
Is that a picture that you took the morning of August 28, 2014?
Yes, sir, it is.
Showing you State's Exhibit 9 for identification. Do you recognize that?
Yes, sir.
What is that?
That's a close-up of the cut to Megan Brown's thumb.
Fairly and accurately depict what you observed on the morning of August 28, 2014?
Yes, sir, it is.
Showing you State's Exhibit 10 for identification. You recognize that?
Yes, sir.
And what is that?
That's my business card and the case number next to the cut on Megan Brown's thumb.
It's fair and accurate depiction of what you observed the morning of August 28, 2014.
Yes, sir, it is.
Judge, at this time, State would like to move State's Exhibits 7, 8, 9, and 10 into evidence.
Any objection?
No, Your Honor.
All right, they'll come in as 7, 8, 9, and 10 into evidence.
Turning your attention to State's Exhibit 11 for identification. Do you recognize that?
Yes, sir.
And what is that?
That's a picture of a kitchen knife Megan Brown advised was used during the...
Without going into that,
Okay.
kitchen knife, where did you get it from?
The kitchen.
Okay. And was it lying there on the counter by itself?
Yes, sir.
And you collected it in evidence?
Yes, sir, I did.
Did you take a photograph of it?
Yes, sir, I did.
And does this photograph fair and accurately depict the kitchen knife that you collected into evidence?
Yes, sir, it does.
Judge, at this time, State would like to move State's Exhibit 11 for identification into evidence.
Any objection?
No, Your Honor.
All right, States 11 will come in as 11.
I'll turn your attention to State's Exhibit 12 for identification. Now, this is not a photograph you took,
No, sir.
but do you recognize the area it depicts?
Yes, sir.
And what does it depict?
That would be the living room and the front entryway of the residence.
Is it a fair and accurate depiction of the general layout of that room?
Yes, sir.
And more or less similar to the way that you observed it the morning of August 28, 2014?
Yes, sir. The two couches right there. I remember being there.
Okay. And turning your attention to State's Exhibit 13 for identification, you recognize that?
Yes, sir.
And what is that?
That's a picture of the bedroom to the south when I walked into the hallway to go to the little boy's room.
And is that the bedroom that we previously discussed you observed there was a mattress in?
Yes, sir.
Okay. And aside for the furniture in the room, is it a fair and accurate depiction of the general layout of that room?
Yes, sir.
And to be clear, this is also not a photograph that you took?
No, sir. I did not take that photograph.
Okay. Judge, at this time, State would like to move State's Exhibit 12 and 13 into evidence.
Any objection?
No, Your Honor.
All right, 12 and 13 will come in and evidence.
Judge, permission to publish dates 2 through 15 on the big board.
You will? You may publish?
May do something. But can you describe again, what is the jury looking at?
Yes, this is the front of the residence the morning I was there.
And in particular, what is that in the west garage?
That would be a silver minivan, which is parked in that garage.
Okay. And that stairwell there, is that the stairwell you're referring to that you have to go up in order to reach the front door?
Correct. I have to walk that stairwell to reach the front doors.
And behind this tree in this area here, is that another garage?
Yes, sir.
And this window here on that would be the right side of the photograph, is that the southeast bedroom that we had been talking about there being a mattress in?
Yes, sir.
And again, can you explain to the jury what this is?
This would be the child's bedroom. Picture of the doorway, and then looking into the child's bedroom.
There are a couple of pictures to follow regarding a specific corner in the bedroom.
Mm-hmm.
Where in the bedroom is that corner?
That corner is going to be in the left corner. Right here.
And what are we looking at here?
This would be the left corner, and then this is where the call was in reference to where I was at for the morning, that morning of.
And what are we looking at here?
This is a close-up picture I took of the container boxes with the blood on top and then blood down here also.
And what are we looking at here?
This is a close-up of the blood splatter on top of that container box.
Deputy, you don't get a career in
Oh,
photography.
hold on. I have a juror. Can you not see?
Oh, I'm sorry. I'm sorry, ma'am.
Yeah. No problem. Nice work over there. All right.
What are we looking at here?
That's a picture of Megan Brown.
Now, is this the front door she's standing in front of?
Yes, sir, that's correct.
And behind her in the doorway, what do you see down there?
Behind her, I see a gate back here.
More particularly, low to the door in this area? See what I'm looking at? Right next to her shorts?
The dog here?
Yes.
Yes, yep.
Did you notice, were there dogs in the residence?
Yes, sir, there were some small dogs in the residence.
Multiple?
Several, yes.
What are we looking at here?
That's a picture of the cut to Megan Brown's thumb.
And what is this photograph of?
That's a close-up of the cut to Megan Brown's thumb that I took.
I'm sorry, this is State's Exhibit.
This is State's 9.
State's 9. And State's 10?
Correct.
What are we looking at there?
This is a close-up of the same injury to her thumb with my business card and my case number.
Okay, and your business card also includes a ruler,
Yes, sir.
and that would be inches?
Yes, sir.
And State's 11?
This is a picture of a knife, a kitchen knife.
Is that the knife you collected from the kitchen counter?
Yes, sir.
And what are we looking at here?
This is the picture of the living room.
And as a refresher, this is not a photograph that you took?
No, sir, I did not take this picture.
Now, when you were present in the center right of the photograph, a little bit to the top, you see what this is here?
Yes, sir.
What is that?
It's an entertainment center with a television. Or no, without a television, I'm sorry.
Okay, now when you were present in the residence the morning of August 28, 2014,
Yes.
was there a television in that entertainment center?
Yes, sir, there was.
And states 13? Could you remind us what we're looking at here?
Yes, sir. That would be the other bedroom, which is on the south end of the residence.
And that's the bedroom that we referenced in the windows in the first photograph we were looking at?
Yes, sir, that's correct.
Now, when you were present in this residence the morning of August 28, 2014, approximately where was the mattress?
When I walked into this area, I remember seeing a mattress down in this area here.
Sort of up against the window, laying?
Sure, so when you left Ms. Brown, you told her if Mr. Matos ever came back to immediately call you up, is that what you're saying?
I advised that part of our protocol is that if we have a suspect, we have them, we advise them to call us if he confirms.
Thank you, sir. The one I wanted the last one, obviously. Mr. Heikerkin, with regard to this bedroom that you described that we showed the jury in the southeastern part of the house, this is the one where you referenced the mattress, correct?
That's correct, yes, sir.
Am I I didn't see exactly where you pointed, so am I correct to assume that the mattress was, when looking into the room, on the right-hand side in the back in the corner?
In that area, yes. I remember seeing a mattress on the ground.
All right.
Lane, it'd be west to east.
Just for the record, which number is that?
That's 13.
Okay, so we're at states 13.
So was the mattress up against the curtains, the back window?
I couldn't tell if they was all the way up, but in that general vicinity, yes.
And this is several years ago, right?
Yes, sir.
So is it fair to say you're not 100% sure exactly where the mattress was?
I remember seeing the mattress. I couldn't tell if it was exactly against the wall.
Okay, so it was more closer to the back wall where the window is, correct?
Yes, sir.
And would it be more to the right or to the left of the room or in the middle? As far as you can recall, if you do remember.
To the right of the
To
room.
the right. So fair to say it was more to the right corner looking into the room?
Yes, sir.
And for the record, this door opens in as opposed to out, correct?
That is correct.
Thank you, sir. Now, Mr. Hydrigan, the jury already was published photographs of an injury to Megan Brown. That's looked like a half-inch cut to her thumb, correct?
Yes, sir.
And you're the one who photographed those pictures, right?
Yes, sir. That's correct.
And that knife you saw, that was a kitchen knife, correct?
Yes, sir.
A Ginsu knife, to be more accurate, right?
I'm not a knife expert. I don't know.
All right, but Megan Brown appeared intoxicated to you, correct, sir?
She advised that she was out prior that night, and she was out with friends.
But regardless of what she advised, when you observed her, she appeared intoxicated to you, isn't that correct?
She appeared that she had several drinks.
Slurred speech?
I wouldn't say slurred speech, but
You wouldn't say slurred speech?
I would say kind of glassy eyes.
Would you have told Detective Kugel when you reported to him later on, days later, that she had slurred speech?
Objection, judgment, proper impeachment.
Sustain.
Can you repeat the question, plees?
I sustain. the
Oh, I'm
objection.
sorry.
It's okay.
Sorry.
She didn't require any medical treatment, right?
Fire rescue did respond to the residents, but they didn't take her from the residence for her injury.
Did they give her a Band-Aid or something? Do you know what they did?
I'm not exactly sure.
Were there any injuries to her throat?
No, sir.
If I could have a moment, Your Honor.
You may.
Welcome back to the Law News Network, everybody. This is Jesse Weber. You are watching the prior testimony in the Adam Matos case out of Pasco County, Florida. It's Veterans Day right now. We have no court in the Adam Matos case. It will resume again on Monday, but we're recapping the entire case today, talking about everything that we've learned. And I'm here today to talk about this case with criminal defense attorney Russell Novack. Russell, let's talk a little bit about what we just watched, that 911 phone call that Megan Brown made, where she said Adam Matos threatened her with a knife. That was the responding officer, saw that she sustained injuries, and then you saw under cross-examination that it was being questioned about whether or not she was intoxicated. Let's explain a little bit about how this phone call might hurt the defense's case, but also how it might not necessarily be as incriminating as they think.
Well, at first look, it hurts the defense case because it shows Matos to be a violent-prone guy. He's such a violent-prone guy that he cut his wife all the way down to where she could see the meat in her finger. Same
day, by the way. Same day of what we think is when the murders took place.
So earlier in the day, he's basically portrayed as a rage ball, somebody who's cutting up his girlfriend, his ex-girlfriend, and he's not looking like a hero here.
Yeah,
this is a bad one for the defense. This is a bad one for the defense. Now, how is this good for the defense? I'm not sure it's good for the defense at all. I mean, the fact that she was intoxicated
because then
doesn't help him.
Maybe she had a drink after this event took place.
It's a nothing.
Yeah,
it's a nothing. I mean, she's a dead victim here. That really. It's not like she's going to be called back from the dead to testify as to what happened, so the fact that she was intoxicated is irrelevant.
Question for you. Great attorney over here. I'm going to ask you a good question that I don't understand what the prosecution did here. So this is an important situation, this 911 call on the same day that we think the murders took place shows that he was violent towards her. Really good for the prosecution. We saw the testimony of Tanya Carlson, who was she worked with Megan Brown at the Fisherman Shack. She was a friend of Megan Brown. Knew her about a month and a half. We saw that there was a testimony before she took the stand. It was a hearing between the judge and the attorneys where they debated what is she going to testify to. And one of the things she was going to testify to is that Adam Matos walked into Megan's place of work. They had an argument. There was tension, and what we know from the meeting, he actually physically grabbed her and moved her out of the restaurant, okay? What the judge eventually permitted this witness to testify to was that there was a tense interaction and that she ended up leaving with him. We didn't know anything about this, him grabbing her. We didn't know anything. She wasn't even allowed to testify to the fact that Adam Matos made her leave that restaurant, that work establishment. What I thought was interesting was the prosecution initially said, we're not going to question her. They took the initiative and said, we're not going to question her about whether Adam Matos used physical force to get her out of the restaurant. I couldn't make sense of that. Why wouldn't the prosecution want that evidence in? I can understand how the judge later on would think certain testimony would be too prejudicial, but the idea that the prosecution wouldn't want that in, what do you make of that?
They wouldn't. I think they just didn't want to run afoul of the judge's ruling. I mean, it's a slippery slope for them because basically they would argue to put that evidence in to show Adam Matos' frame of mind. His state of mind, that he was a rage-filled individual who is not above using physical force against someone. So, and they also, one of the reasons why they put evidence like in is to show or to do what's called completing the narrative. It's scene setting to show that the defendant on the day of the murder was so riled up and so pumped up that he was pushing people out of the way, which ultimately culminated in him murdering 4 people. So
I should note that incident took place about a month before this actual incident, this event took place. But what's interesting is I still don't understand. I mean, I would love to see this evidence come in as a prosecutor and say, look, he's been violent towards her on other occasions. He was exerting dominion and control. The judge made the point that says, I don't want that being heard by the jury. I don't want them knowing that he made her leave. This is now about the statements that Tanya Carlson was making. She goes, forget about the whole point about him actually physically moving her out of the restaurant. I don't want this witness saying anything to the like that Adam Matos made her leave the establishment. All I want her to testify to is that it was a tense interaction, and that he left with her. I just thought it's very interesting, that kind of like what the jury can hear and what the jury cannot hear.
Right. Well, the things that the jury can't hear are the types of evidence or the types of statements that the DA can argue show defendant's propensity towards being violent or the propensity towards committing a crime. So I think, the prosecution playing it safe, after all, this is a death penalty case, they don't want to get reversed. They elected to go the way they did, just to sort of try to bulletproof the record in the event that they get in the event that they get an appeal, which of course they're definitely going to get, it being a capital case.
Let's talk a little bit about the testimony we've seen in the last few days. We saw yesterday the testimony of Anna Cox. She is a blood stain analyst talking about blood spatter. Let's begin from this. She testified about all the different ways that blood can be, dropped. There's, if someone's hit, there's blood spatter different ways. All the different ways blood can end up in a crime scene. We saw testimony yesterday that there was cast-off stains near the closet, which shows that there was it was all, from what I saw, because I was there during the beginning part of her testimony, just tons of Nicholas Leonard's blood everywhere in the, there was one, it was all in this one room, as well as also in the west garage. There was cast-off stains, basically trying to show that he was hit with an instrument. But why is it important for a jury to really hear about the direction of blood and how blood was stained? What's the importance of this? Yeah.
Who did the killing? Who did the killing? Who did the killing? Who held the knife? Who shot the gun? Where are the fingerprints? Where are the bullets? Where's the DNA? Where's the bloody knife?
Let's talk about the idea of like maybe a cleanup, because there's blood everywhere. It was a very sloppy cleanup, whoever committed this crime. We spoke with David DiPietro earlier in the week. He said that it shows that a professional didn't do this, but it was somebody who maybe killed for the first time. I thought it was interesting. We saw the testimony from this bloodstain analyst, and they said there was a chair in the southeast bedroom, had Nicholas Leonard's blood all over this room in different areas, but particularly I want to touch about this chair. The chair was actually found, it was propped up against the closet, and there were actually passive drip stains on the seat of the chair. This lets everyone know that the chair, it was deposited, this blood was on the chair in an open position. But then we know the chair was closed and propped up against the closet door, which says to me either A, that someone's trying to cover up the blood stains on the chair, or maybe they were trying to, I don't know why they propped up against the closet, but this idea that maybe it shows someone tried to clean up this, or tried to cover up these blood stains. Right. We also know there was bloody items in garbage bags. Someone was in the middle of trying to get rid of all this blood. They did a sloppy job. Doesn't it seem like a person who was living at the house, like Adam Matos?
Yeah, I mean, the DA is going to argue that shows Adam Matos' consciousness of guilt. These are the things consistent with how a guilty person would act to try to cover his tracks and clean up evidence of a crime. It's a good, effective argument, and a lot of the time, juries accept it. On the other hand, if you're the defense attorney, you're going to keep going back to, but who was the person? Who was the person that folded up the chair and propped it up against the wall? Who was the person that did the amateurish job of cleaning up the murder scene? Who was it? We don't know. But we're never going to know.
But these items, including a mattress that had Nicholas Leonard's blood on it, was found in the garage. It seems like many of these items were moved from one area of the house to the other. So the idea of somebody, you may not be able to say he swung that hammer because Nicholas Leonard's injuries were consistent with a hammer, but you can show that someone moved those items that had blood on it, and it was probably Adam Matos.
Well, moving the items is not the same.
You are a good lawyer.
Swinging the hammer.
You are a good lawyer, Russell.
It's not swinging the hammer. I mean, you can be the bat boy, but you're not the one hitting the home run over the fence.
So what does that mean, though? Like, let's from a practical point of view, okay? If I'm sitting on the jury and I see that this guy was living at the house, he's cleaning up items. You know, we know that there was about 10 garbage bags that were put out for garbage day. And we know that some of these items these garbage bags had blood on it. There is going to be testimony about somebody who witnessed, it appears to look, the look and make of Adam Matos washing the garage with a hose. Again, if he wasn't involved, if he didn't commit these murders, why would he be cleaning it up?
Because his house is a mess.
His house?
The house is a mess.
You know what I mean?
The house is a mess. Who wants to live with blood in a house? Listen, 2 words for you.
Okay.
2 words.
Reasonable doubt?
Exactly right. Yeah. Exactly right. Reasonable doubt.
Is this reasonable, though?
A reasonable doubt, and the judges, when they charge the juries, will give the legal definition of reasonable doubt. But basically, they'll tell you a reasonable doubt has to be reasonable on one level, and in another way, they'll say a doubt for which you have a reason. I don't believe X. I don't believe Y. I don't believe A, B, C, D, E, F, G. So that's what we do.
Okay.
That's what defense is. We create reasonable doubt. And in order to win the case, you have to convince the jury that they have a reasonable doubt about a certain part of the prosecution's case. Remember, let's say the prosecution's case have 10 elements or 10 components to prove, right?
Yeah.
If the jury has a reasonable doubt about 1 out of the 10, the defense still wins. The defense still wins. The defense still wins.
That's a good
You
point.
only have to convince 1 person out of 12. Maybe it's a little bit more down in Florida because it's a capital case, I just don't know. But you only have to convince 1 person that they have a reasonable doubt about 1 part of the prosecution's case, and the defense wins it.
Well, I think there is something, a little bit of something to the idea that, or what makes this, I think it's a slam dunk case. But the one thing that I would agree is because we don't know exactly what happened in that house in terms of the murder. We don't know who really, we don't have evidence, DNA evidence linking it. I think there's something to it. I do have a question for you about, and we talked about it in the break, the defense reserved their right for an opening argument until the prosecution closes their case, and if they decide to put on their own case. What did you make of that? I haven't seen it. Reserving a right to not make an opening argument. I'd like your thoughts on that.
You know, as a matter of tactics, I always make an opening statement. Certain times you make what's called a non-opening opening, and what I mean by that is in a non-opening opening, you don't address the specific points of evidence that may or may not come up in the case. In a non-opening opening, you remind the juror of the solemn obligation as jurors to be fair, hold the prosecution to their burden, to remember the defendant's presumption of innocence, and so forth. It doesn't take very long. It's usually anywhere between 2 and 5 minutes, then you sit down. Mm-hmm. That way you're not arguing that you're going to prove something that you may not be able to prove, or that the prosecution was going to prove something that you may not be able to disprove. It's a safe way to do it. But what my own philosophy of these things is, when you're doing a trial, when you're defending somebody, you have to sell it. You have to sell this person's innocence every step of the way, and you do this by getting subtle messages across, or not so subtle messages across, from the minute you get into the courtroom until the jury comes back with a verdict. So this would include when the judge is giving the jury their preliminary instructions, when you're picking a jury, when you're doing an opening, when you're cross-examining, when you're making motions, when you're making objections, and how much you actually get up and say, I object grounds of X, Y, Z. Sometimes you don't say anything. Sometimes you make an objection just to derail the prosecutor when he's on a roll. So things like that. It's all part and parcel of conducting a trial and trying to win it.
See, I thought the prosecution delivered such a strong opening of a table of contents of where their case was going that to not hear anything from the defense, I'm already siding with the prosecution. Because there's so many times those cases start, prosecution delivers their opening argument. I said, oh, that's a really good point. And then the defense goes and presents their opening argument. I said, well, that's another good point, and now I'm stuck. Now I really want to hear the evidence. But to hear such a strong opening, and now the prosecution's putting on their case, and it's consistently being backed by the proper evidence and testimony, I mean, the balance here is really in favor of the prosecution.
You can't let things go unanswered. I mean, this is the nature of our adversarial system, right? You can't let things go unanswered. Prosecution says black, you say white. Prosecution says left, you say right. Prosecution says black, you say green. Whatever. You need to get out there. You need to always work towards that acquittal in large ways and small. You never stop.
I want to bring up an argument that might be used by the defense at some point. we're kind of seeing flavors of it, so I want your opinion. Aaron Keller, our very own Aaron Keller, made a good point that perhaps what the defense is trying to do is create the situation of a powder keg, that there were such high emotions between Adam Matos and the Browns regarding, his ability to support the family, regarding the development and taking care of Tristan, young Tristan, that there was a high emotions, and especially with what happened earlier in the day with holding, that 911 phone call, we know that emotions probably were running high. Aaron said, is it not possible that the defense will go with the theory that perhaps this was like a powder keg waiting to blow, and that, we don't know who struck first, we don't know how this situation resulted. We knew testimony from Michael Unsworth, who was Nicholas Leonard's friend, who said that Nicholas had was going to bring a gun to the Browns' home to protect Megan after what happened with the 911 call. But this idea that that perhaps Adam Matos was defending himself, or it was a heat of the moment kind of a situation and not a premeditated murder. Do you see the flavors of that maybe happening for the defense?
Well, heat of passion only gets you a manslaughter. It's still probably going to get you a couple of decades in state prison, so it's really not a clean win. There are basically, I don't want to sound like the announcer for Law and Order, but basically in the criminal justice system, there are two types of cases. There are whodunits and what happened. Mm-hmm. It's very rare that a case is both, and it's not such a great strategy to argue both theories to the jury most of the time. So in my view, this case is a whodunit and not a what happened. So you can't go heat of passion. Mm-hmm. And also, I don't think the evidence supports it. I mean, from what I've seen and what I've read in our discussions, both on camera and off, this looked like a slaughterhouse.
Yeah.
This was not a clean one-shot heat of passion. Oh my God, I shot somebody, I'm going to run away and throw the gun in the canal. This was blood all over the place. Somebody was beaten to death with a hammer. Other people were shot in the head. I don't think heat of passion is going to fly here. I don't think it's a smart strategy. Look, I may be wrong. Like, I don't know what sort of evidence the defense has in their case file, but to me, at least at this point, this is a straight-up whodunit. Reasonable doubt, circumstantial evidence is weak evidence, and that's the road that I believe they ought to be traveling here.
The reason I ask this is because I keep seeing testimony about Gregory Brown, the father of Megan Brown, how he had back surgery and he really couldn't carry boxes, he really couldn't help move the family, and he was weak, he was in a weak state. And I keep wondering, why are they bringing this up? Is it the idea that he was a helpless victim and he was not someone who could have been the attacker or the one who started this?
Yeah, they're just trying to close the defense off here. I mean, it's, a lot of times a prosecution overtries cases. It's just sort of the nature of the prosecution beast. They try to bring everything, including the kitchen sink and your neighbor's kitchen sink, into the trial. So I'm not really quite sure why that's there. I don't think, they might not need it. I mean, I think the circumstantial evidence here, and there's a ton of it, the after-the-fact stuff about Walmart and the Craigslist stuff and the pizza and the living in the house with the blood-stained walls and furniture and so forth. That's a strong evidence for the prosecution. I mean, it's circumstantial, and there are things you can say in your summation about the weight of it and how much weight you should attach to it, or if you should attach any weight to it at all. But at the end of the day, this case is a straight-up whodunit.
And who did it is the question, right?
That's
the question that you're presenting as a defense attorney.
Who did
it? Despite all of this other evidence coming forward about Mr. Matos' behavior, you could still say it's a whodunit at the end of the day.
That's right. Whodunit.
You're a very good lawyer.
Thank you.
Mr. Novack. So
Thank you.
First of all, thank you so much for joining us here on the LawNewz Network. We really appreciate your time
Thanks
and analysis,
for having me.
both for Taylor Swift as well as the Adam Matos case. So thank you so much, and we can't wait to have you back on.
Always a pleasure. Thanks.
Thank you.